All right. Good evening, and thank you for joining us. My name is Mark Burgess, and I'm a librarian with the Civic, Cultural, and Literary Engagement Department at the Chicago Public Library. Tonight's virtual event is part of our Law at the Library series in partnership with the Evanston Public Library and the Chicago Bar Association. We are continuously grateful to the CBA for their continued support of this public information series. And the presentation portion of tonight's program will be recorded and available for later streaming on the Evanston Public Library YouTube channel. And during tonight's program, we'll be monitoring an online chat for questions from the audience for a Q&A following the conversation or during the presentation if Carrie can get to it. So please type your questions by clicking the Q&A button at the bottom of your screens. It might be hidden under the three dots with the more, and we'll get to them at the conclusion or while time allows. And now I am pleased to introduce our speaker for this evening, Carrie Peck of Peck Ritchie LLC, to talk about wills, trusts, and estate planning. So thank you again for coming. And with that, I will hand it over to Carrie.
Thank you, Mark. Good evening, ladies and gentlemen. Thank you for joining us. I'm pleased to be here tonight on behalf of the Chicago Bar Association. I was president of the Chicago Bar Association a few years back, a great organization today with about 17,000 lawyers. And tonight we're going to talk about planning ahead, wills, trusts, and estate planning. There will be a slide presentation during the course of our discussion. If you have questions, try and put them in the chat as Mark suggested, so we can get to them in a timely fashion, perhaps during the presentation. So it'll be, I can answer the questions in a timely fashion regarding the slides that you see. So the law firm of Peck Ritchie focuses on trusts and estates, both litigation and planning. And we're pleased tonight to discuss what is estate planning documents and strategies, modern planning considerations, along with probate court and estate complications. So Lauren, you want to go to the next slide, please? And let's go one more. So, life gets away from us. People don't normally, under the circumstances, anticipate that someone's going to get sick. And so the unthinkable happened. We thought we had more time to plan. My husband was diagnosed with early onset dementia. Can we get our estate plan done very quickly? Unfortunately, this is a pretty common situation that we face at my law firm on a daily basis. Next slide, please. So 1 out of 4 Americans without a will never plan on getting one. And more than 40% say they plan on waiting until there's a medical diagnosis, whether that medical diagnosis is Alzheimer's disease or whether that medical diagnosis is cancer. It's clear that a lot of people don't ever plan on doing estate planning until basically the doctor gives them bad news. Next slide, please. So what is estate planning? Estate planning primarily is used for the distribution of estate assets upon someone's death. Estate planning also includes advanced planning for the management of financial affairs, should you become mentally incapacitated. It includes advanced planning for healthcare decision making. Both of those items are what we call powers of attorney. It may include asset protection. It may include estate tax planning to reduce taxes, and it may include avoidance of probate. In Illinois, if you die with assets in your name alone in excess of $150,000, the law just recently changed from $100,000 to $150,000. Again, assets in your name alone, or assets that have perhaps joint tenants, payable on death accounts. We'll talk about it quite a bit more. You can avoid probate. What is probate? Probate is a post-death court proceeding. So let's go to the next slide. So even before estate tax planning, the goal of estate planning as I mentioned, it is to protect assets from creditors, to preserve family wealth for future generations, and to provide support and income flow to the family under all circumstances. We want to manage the assets for those who can't manage it themselves. Perhaps they're cognitively impaired, they were hurt in a car accident, they're diagnosed with dementia, a variety of physical and or mental maladies that will prevent someone from managing their assets and or their healthcare decision making. And last on our list for estate planning is we might want to do business succession planning. Who's going to take over the business when mom or dad die? Next slide, please. So what can you expect when you do estate planning? Well, a small estate plan focuses on how and who's going to manage your assets for your benefit during your lifetime, should you ever become unable to manage them yourselves. None of us believe that we'll ever be mentally incapacitated and or physically incapacitated, preventing us from managing our own affairs. But unfortunately, if we have a stroke, sometimes if we have a heart attack, certainly if we are diagnosed with Alzheimer's disease, depending on what stage that disease is, we may not be able to manage our own assets. So under what circumstances does it make sense to distribute your assets during your lifetime? How and by whom your personal care and health care decisions will be made during your lifetime if you're not able to make those decisions for yourself. How and to whom your assets will be distributed after your death, and who will be guardian of your minor children should you die leaving behind children under the age of 18. A large estate plan may focus on various ways of preserving the estate assets for the beneficiary's benefit, and we might do tax planning to reduce or postpone estate taxes. Next slide, please. So you can see from the picture on the screen, one needs to have mental capacity in order to do estate planning. And that mental capacity, of course, may shift, it may go up, it may go down depending on one's illness or diagnosis. But the mental capacity necessary for the appointment of an agent, we'll talk in great detail, an agent under a power of attorney for healthcare or a power of attorney for property, is not the same capacity necessary for managing one's affairs. It's also not the same capacity to engage in estate planning. So there are basically two types of mental capacity. Testamentary capacity, which you can see is the ability to understand what an individual is signing and the implications in doing so. It's less rigid than contractual capacity. Contractual capacity requires that an individual have the ability to understand the terms and the effect of the contract, including potential negative effects. It's required to sign deeds, trusts, and what we call non-durable powers of attorney, but in Illinois, we primarily want to use durable powers of attorney. Next slide, please.
Gary, we have a question.
Okay.
Sarah asks, what dollar amount is considered a large estate?
I would say in the millions, generally, something exceeding $1 million+.
Thank you.
Okay, so on diminished capacity, and if you have questions, please, I would like to do them again in a timely fashion rather than waiting to the end because we may not have time. Diminished capacity, attorneys are constantly asked to assess capacity, their client's capacity, because we need to know that a client has the capacity to sign a will, sign a trust, sign a power of attorney. Some clients are obviously incapacitated. They go to the doctor writes a letter, it says they either have capacity or they don't. And frequently that's necessary in our practice because often we can't determine if an individual has capacity. And capacity is not an all or nothing condition. We lawyers rely on the medical community to tell us if John Doe has the capacity to execute documents. And of course, in Illinois, you must have capacity to execute documents, or they're going to be found to be invalid and challenged perhaps by family members who don't get as much as another family member from the estate. Next slide. So a common estate planning documents and strategy would include a last will and testament. Last will and testament is effective only upon your death. It has no validity during your lifetime, unlike many of the other things on that slide. So trusts come in two different forms. Trusts are a living trust, a revocable living trust, and trusts also can be irrevocable. Now you can tell from the title, a revocable living trust means it's amendable, changeable, and revocable. An irrevocable trust is the exact opposite. Once it's signed, we can't change it without a court proceeding and a judge authorizing that it be changed. Powers of attorney come in two forms or two flavors. The vanilla is a power of attorney for health care, and the chocolate is a power of attorney for property. What we do with a power of attorney, and we'll talk again in more detail, is while we're competent, we name an agent, someone that's generally a close family member, to make decisions for us when we're not able to make our own decisions in those two domains, one healthcare, one the management of property. Don't be confused, the term property doesn't include just real estate. It includes all forms of property, tangible personal property, bank accounts, real estate, things of that nature. A transfer on death instrument in the legal world is called a TOD. Transfer on death means, Carrie Peck, I have a transfer on death instrument with Jane Doe. When I die, the money or the property goes to Jane Doe. Transfer on death. Joint tenancy accounts, a very, very common method for generally married couples to own. Husband and wife in joint tenancy own a bank account, they own a house, and upon the death of one, the property passes outside of probate, outside of a court proceeding, to the other joint tenant. But choose your joint tenants very carefully, because if you open a joint tenancy account at the bank, that joint tenant has complete 100% ability to take the money. Make sure the joint tenants love you more than they love your money. We are frequently involved in scenarios where joint tenants steal the money. It's unfortunate. So, as I already mentioned, a last will and testament is operative only upon your death. No validity during your lifetime. It appoints an executor. That's the person you trust to manage the assets and the distribution of those assets after you're gone. It directs the payment of your debts and your last expenses, and it directs, as mentioned, the distribution of your assets upon your demise. And you could distribute your assets by joint tenancy or by a transfer on death instrument, but if it's in your name alone, it has to be distributed under the terms of a will. And don't be misled, a will is a public document. It must be filed within 30 days of your date of death with the clerk of the circuit court. If you live in Cook County, that's the Daly Center. And a last will and testament does not avoid that post-death court proceeding called probate, unless proper planning is done to include a trust. Next slide, please. So let's talk about trusts. As I mentioned, there's two basic forms of trust: a revocable living trust, which in large measure takes the place of a will, but we strongly recommend you have both. And the assets are assigned to the trust. So the Carrie Peck Revocable Living Trust, I put my house into the trust. I put other assets into the trust. I changed the names on my bank accounts. I put them into the trust. Why do we want to do this? So that the assets are not in my name alone, in excess of $150,000, as we discussed at the outset of our presentation tonight, and are below $150,000 in our name alone. So we put the assets in a trust, a revocable living trust, and we avoid that post-death probate proceeding. Now, unlike a will, the trust is a private document. It need not be filed with the clerk of the circuit court. It may be amended, changed, and or revoked. It also avoids the need for guardianship. Guardianship is a lifetime probate case. Guardianship is a determination that an individual lacks the capacity to manage their own health care and or financial decisions. Guardianship is necessary when an individual does not do planning, advanced estate planning, and execute a power of attorney for health care and a power of attorney for property. Because the execution of those documents names an agent, an individual that you trust to make decisions for you in healthcare and financial management, avoiding that lifetime probate case, that lifetime determination of who should be your guardian. Guardians also come in two forms: a guardian of the estate, management of assets, and a guardian of the person, management of healthcare. So a revocable living trust also allows for estate tax planning. The individual creating the trust cannot use it for asset protection. And it allows for the trustee, the successor trustee, to manage the assets for the beneficiaries. It can provide some creditor protection, and it's an integral part of an estate plan. So typically, estate plans today include 4 documents: a will, a revocable living trust, a power of attorney for healthcare, and a power of attorney for property. Now, switching to look at the other side of the slide, as I mentioned, trusts can be irrevocable. That means that they cannot be changed, and more often than not, they're used to facilitate gifts to children or individuals that require asset protection, somebody who might be disabled. The grantor, that's the person that creates the trust, cannot make changes, cannot take the money back, and a lot of complex estate tax reduction strategies include irrevocable trusts. Okay, next slide, please. Lauren, can we move ahead to the next slide, please? Lauren, can you hear me? Okay, well, Lauren, could you, oh, there we go. All right, so the next slide is the slide that addresses the power of attorney. Those of you that are old enough may remember the Doublemint twins that were on TV and commercials. And why are we using the Doublemint twins? Because the individual signing the power of attorney is naming an agent, a legal clone, somebody that they trust to act for you under certain circumstances. So I name an agent. I may name my wife, I may name one of my children, but I name someone that I trust that's going to act in my best interest. Next slide, please.
Sorry, can you hear me now?
I can now, yes.
Okay, sorry. Okay, so there's a couple of questions.
Okay.
One of them is, do you need a doctor's clearance to sign your will if you're 100% healthy?
No. No, you don't.
Okay. Another question is, if an individual's assets exceed $150,000, can they establish more than one trust?
They can, but there's no reason to do that, unless you want to put some of it in an irrevocable trust and some of it in an irrevocable trust. But in general, we don't use irrevocable trusts other than specialized circumstances. I would suggest, in general, I don't know the details of your estate, we would use a revocable living trust to avoid probate.
Okay. And then if you are married without children and have joint ownership of your home and bank accounts, do you still need a will and trust?
In general, you probably don't, but you still need a power of attorney. Because if you have a stroke or you get seriously injured in an auto accident, you want to make sure that your wife or your husband, depending on who's injured, has the ability to manage your assets. Now, if everything's in joint tenancy, they may have the ability to manage your assets without powers of attorney. But it would be important to consider the execution of powers of attorney to ease the management of your health care and your assets. Healthcare obviously is not covered by joint tenancy, so I would strongly urge you, even if everything's in joint tenancy, to execute a power of attorney for healthcare.
All right. How old does a child have to be to do a toady?
A child,
Yes.
in Illinois, the age of majority is 18, so anybody over the age of 18 can sign legal documents. So long as
Okay.
they're mentally competent.
And then with regard to joint tenancy, if a child is on the bank account, does everything you mentioned still apply?
Depends if that child's over the age of 18 or under the age of 18. So if it's over the age of 18, it'll be fine. If it's under the age of 18, then no, it doesn't work that way. You cannot leave that money to a child under the age of 18.
Okay. As a young person starting out, is it too early to seek legal guidance in drafting a trust despite not having much in the way of savings or investments?
I would suggest that it's never too early. It's probably more likely that we would use just a simple will at the outset if you're just starting out, and a power of attorney for healthcare and a power of attorney for property. It's probably not likely we would create a will, excuse me, a trust at this early stage of your life.
The $150,000 figure mentioned for assets, is that just for monetary assets or does it also include real estate?
It includes real estate and monetary assets.
How do you handle trusts when there's property in multiple states?
In general, you can put those assets into the trust. So if you own a winter home, for example, in Florida, you could put that asset into the Illinois Revocable Living Trust. Now, you
Perfect.
need a Florida deed, and you have to make sure it's recorded properly and things of that nature, but it can be done.
All right. What happens if you have property and assets outside of the US? Will a trust or will also cover those?
It's a whole different conversation for a different presentation. So, we can't get to that tonight. Let's move
Perfect.
on to the next slide, and so that we finish our presentation. I appreciate, by the way, all the questions here. Let's move ahead. So, power of attorney for property appoints an agent to manage your financial affairs upon your incapacitation. Again, it avoids that lifetime probate guardianship, and it includes the authority to manage real estate. It's particularly useful to manage assets that we can't put in joint tenancy or in trust, HSA accounts, IRAs, retirement plans, or property not put into the trust. A power of attorney agent can also handle income tax filings, create estate planning documents if the document says so, do Medicaid planning, change titles, and gain access to all types of medical and other information, although most medical institutions will want a power of attorney for healthcare in that regard. Next slide, please. So power of attorney for healthcare, again, is the opposite side of the equation. Appoints an agent to make healthcare decisions for you. It gives your agent general directives that must be followed, but allows some flexibility here. This is important that you talk to your agent on your power of attorney for healthcare. Do you want to be put on life-saving devices when, the question is, are you better off? Are you in pain? What's the doctors recommend? Have a serious conversation in the context of end-of-life decision-making with the person you name agent. And, your agent's going to decide what you would have wanted done. And it also allows your doctor, the hospital, to release medical information to whom you choose as your agent. Everybody's heard the phrase HIPAA, HIPPA. HIPAA doesn't allow us to tell you. HIPAA doesn't allow us to give you records. This document overcomes those objections and the law on HIPAA. Next slide. So, as I mentioned already, we want to select a trustworthy agent who's capable of acting independently, who can do the best job. We want to select a successor agent, meaning a second agent, in case the primary agent is not able to act. Again, this document I sign while I'm competent. I name the first agent. Probably you're going to name your spouse if you have a spouse. If you don't have a spouse and you have children, you might name one of the children, and you might name a successor agent as perhaps another child. But be aware that we see every single day agents stealing money, relatives financially exploiting their quote unquote loved ones. I've said this before, I'm saying it again. Make sure the people you choose love you more than your money. Don't assume that a close family member's helping you just because they say they are. Again, you can see the red sign, stop elder abuse. The FBI recently reported billions of dollars has been stolen from older adults. Next slide. So we might want to consider limiting the agent's power. The power of attorney may be drafted to prevent the agent from taking actions not intended by what's called the principal. I'm the principal if I give someone my agency to be an agent. I'm the principal, they're the agent. We might want to say the principal has decided the agent cannot change the estate plan, cannot change beneficiaries, cannot gift money to the agent or the agent's family, cannot admit me to a nursing home, cannot sell my home, or any actions contrary to the wishes of the principal. But again, don't forget, the principal is now cognitively impaired as a result of either medical or accident. So we want to, again, pick somebody that we can talk to, and we want to give them powers, or we want to take them away. Now, next slide. Should there be no power of attorney for healthcare, in Illinois, we have what's called the Healthcare Surrogate Act. Usually, the Surrogate Act is used under emergency circumstances. You're in an auto accident, you're taken to the nearest emergency room, your family rushes to the emergency room, you're married, your wife or husband is there, and the hospital says, well, do you have a power of attorney for healthcare? No, we never got to it. Okay. We'll use the Healthcare Surrogate Act. So if the individual has a court-appointed guardian, and most don't, that person can make decisions. But you can see on the chart, the patient's spouse could make a decision. If you're not married or you're divorced, an adult child, son or daughter can make the decision. And then you can see it kind of branches out parents, if they're alive, can make decisions, brothers or sisters. So they start on the left and go all the way across. And obviously, if you have close blood relatives, they're going to be in a position to make decisions. Again, they're not going to be able to consult you because you're going to be perhaps in the operating room or in some dire straits in which they've got to make decisions regarding what type of health care you're going to receive. Next slide, please. So this was our transfer on death instrument. Under Illinois law, it gives attorneys and individuals a good way to transfer real estate outside of probate. It applies only to residential property. It's revocable any time before the owner's death, even if the toady contains a different provision. Transfer on the toady, transfer on death is the owner's death. No, even if the owner becomes disabled, this scenario doesn't apply for transfer. The beneficiaries become the owners upon the death of the predecessor owner. Beneficiaries can be designated concurrently or successively, which means A and B together, or A succeeds B, or B succeeds A. And the designation can be contingent upon conditions existing at the owner's death, such as I created toady, and if I leave it to my wife, she has to survive me in order to get it. If she's gone, she doesn't get it under the toadies. Next slide. Joint tenancy accounts. Common reasons to use joint tenancy. We want to pay bills. We want to pass title to property, real property, upon death. We might want to protect assets from nursing home expenses. We might want to co-sign a loan for home repairs or improvements. We might want to own it in joint tenancy. The house, A and B, husband and wife, upon the passing of one, it goes to the other. Issues in using joint tenancy. I talked about it, but I have to say it multiple times tonight. Co-owners in a joint tenancy can withdraw 100% of the money. That is not the case in joint tenancy of real estate. Joint tenancy of real estate can only be transferred with both signatures. Money or property does not pass under a will if it's in joint tenancy. It goes to the surviving owner. Thanks, Lauren. Let's move ahead. So modern planning considerations, we got a lot of families now that are single parents. We have stepchildren. We have some people that are adopted. We have a fair number now of cohabiting non-married couples, as well as same-sex couples. They all bring different issues to an estate planner in the context of appropriately planning the estate. So, single parents. All parents should have an estate plan that focuses on what happens to their minor children in the case of death, especially important for single parents whose child other parent is unwilling or unable or, deceased to take over. So a will is going to be necessary for single parents to appoint a guardian. And of course, you want to appoint a guardian for your children that you trust to manage their assets and take care of them. And what kind of upbringing do you want? You want your children obviously educated, and you want them, as I mentioned, taken care of. You want to get them good health care. Next slide, please. Second, a trust can be created to prevent any young or minor children from receiving money. While a 16-year-old may no longer need a guardian to make their own health care decisions, they will need someone to manage their money. You can create a trust so they don't get all that money at the same time, go out and blow it, buy an expensive car, go on a fancy vacation. Trust documents are important for that and can be put into a will. Third, a single parent should designate a power of attorney to avoid putting a young child in a difficult position when it comes to care, should your single parent die or become incapacitated. In Illinois, you can appoint a power of attorney who will make healthcare decisions for you when you're incapacitated, but not deceased. Next slide, please. So stepchildren, a lot of people today are involved in multiple marriages. If you die without a will, your stepchildren do not inherit anything unless they're adopted. Illinois rules of intestacy, which is a fancy word for dying without a will, do not include stepchildren. Again, do not include stepchildren. If you want your stepchildren to inherit, it's important that your will and or your trust say so. Next slide, please. In Illinois, an adopted child severs the parent-child relationship between the biological parents and the child. So a child adopted away from you has no inheritance rights from its birth parents. Very, very important. Next slide. Cohabitating non-married couples, very important. Common law marriages are not recognized. If you're married and you die without a will, your surviving spouse will receive half of your assets and your children will receive the other half. Again, I'm saying it on purpose. You die without a will, your spouse gets half, your children get the other half. You may not want that to happen. You may want your spouse to get 100%, and the children might inherit from the second spouse to die, but without a will, 50-50, spouse and children. If you're not married, your surviving spouse basically gets zero, unless you have documents to say the contrary. So in order to protect your partner, unmarried partner, you must make sure that you have written estate planning documents. Next slide, please. Unmarried couples, it's important to appoint a power of attorney agent. If you want to make sure the two of you are able to make financial decisions for each other, should one of you become incapacitated. Otherwise, the decision could be made by another family member. And you think about going all the way back in our slides to the Surrogacy Act. If you don't have a power of attorney, you're unmarried and you're cohabitating, and you have not signed a power of attorney nominating basically each other to make decisions, we're going back to the Surrogacy Act, and your perhaps parents, your siblings are going to be making decisions. Next slide. Same-sex couples in Illinois, married same-sex couples can distribute assets the same way as a married couple. Unmarried heterosexual couples, unmarried same-sex couples, again, no right to inherit without documents or joint tenancy beneficiary designations that provide for that inheritance. Next slide, probate court. This is where it gets scary. This is a forum for estate issues. Most estates, run smoothly and may often be completed and closed without issue. However, family members and beneficiaries, if they don't get along or the estate plan was not crafted properly, complications arise. So I've talked about probate. What is it again? It's a court-supervised process by which the executor, or if you die without a will, the administrator, is appointed to collect the deceased person's assets, pay the debts, distribute the balance to those entitled to receive. Probate law is governed primarily by state law and secondarily by the applicable local county procedure. Persons entitled to receive the estate are those identified in the last will, or if none, under the laws again of intestacy. Example once again, husband dies, leaves a wife and 2 minor children. Wife gets 50%, the minor children each get 25%, and the law will require that a minor's estate with guardians appointed, perhaps the wife, be appointed, and the money's subject to court supervision, which probably is not what the husband intended. Next slide. So potential estate complications include a challenge to the will's validity. It either was not executed properly, or as in the next slide, there were issues of forgery, fraud, mental incapacity, undue influence surrounding the execution. Undue influences: mom is taken to a lawyer by the oldest child who cuts out the other 3 kids. That's undue influence. Generally, unless mom is competent and literally says to the lawyer, I want my oldest child to get everything, I don't like my other 3 children, or I gave them gifts during their lifetime, I don't want to leave them anything. Will construction, the terms are ambiguous. I leave my assets to my children without a designation of how many, what their names are. Do you have stepchildren? Things of that nature. An heirship dispute, where the identity of the decedent's heirs, HEIRS, is disputed or unknown. People die and they don't have, quote unquote, close heirs. There are companies that go out and find long distance or kind of distant cousins to come in and claim. Creditors contested. If you die and you own money to your Discovery card, on your American Express card, to the IRS, to the Illinois Department of Revenue, they're all likely to file claims against your estate, which are adjudicated in the courtroom. Citations to discover or recover are the type of court proceedings when someone refuses to turn over assets or information to the executor or administrator. Again, executor with a will, administrator without, for property that purportedly belongs to the estate. A breach of fiduciary duty when the administrator or the executor acts inappropriately. They may take some money, they may refuse to distribute money. And of course, last one is an accounting, when the accounting of the estate activity is never produced or it's incomplete. And what are the fees charged by the lawyers, the accountants, and so forth? Are they going to be disputed? Next slide, please. So Elvis is an example of a probate proceeding gone awry. Elvis had about $10 million. He lost 90% of his assets in the probate process to debts. He ran up a lot of debts, almost $4 million. He had fees, administrative, legal, and executor of almost $2 million. He had taxes in excess of $3 million, and he only left his heirs slightly less than $1 million. If he had used a trust, he probably could have avoided a lot of these problems. So let's take a look at the most obvious part of our presentation. Death is not a comfortable conversation for all of us. However, if you want to save your loved ones added frustration during their heartache of your death, get organized, get your documents done, get them completed, and tell somebody that you trust where the documents are. Why? Because you can do a will, you can do a trust, and we'll never find them. So as you can see on the slide, that's the elephant in the room. Key takeaways: you do not have to be wealthy to do proper estate planning. No matter the size of your estate, proper planning is important. Mistakes turn into costly and potentially public proceedings. And when you review your estate plan, does your will or trust match your wishes? Don't forget, your wishes are going to change. Your relationships change, your assets change, and it's important your documents change. Are your documents titled correctly? Do you want them in joint tenancy? Do you want them in a trust? If it's in a trust, have you properly put those assets into the trust? Change the title of those assets. And again, are you comfortable with the agent you named 10 years ago, or 5 years ago, or last week? Did you have a falling out? Do you want that agent to manage your health care? Do you want a different person to manage your asset and property? That's a decision that you need to make. But again, you need to discuss it with your agent, and you need to trust your agent. So, final slide, we offer a free initial consultation in conjunction with these areas: disputed estates, estate planning. We have offices in downtown Chicago and the suburbs you can see: Northbrook, Oak Brook, and Lake Forest. And if you take a look at our website, you'll see that we've been doing this for decades and decades. We're highly regarded. We're ranked by as one of the best law firms under their rankings, leading lawyers, things like that. And I'm chairman of the Illinois Supreme Court Commission on Elder Law. I've written several books for the American Bar Association on Alzheimer's disease, one for lawyers, one for non-lawyers. And we also, Peck Ritchie is the only law firm that's a legal education partner for the Alzheimer's Association as well. Our offices are convenient to, downtown and all the suburbs, as I mentioned. If we can help you, please let us know. If you have any questions, let's get to them.
All right, Carrie, there's a lot of questions here. One of them, which we get quite often, is asking about the online services to do estate planning. For example, freewill.com. Are these things legit? Should they be used?
Well, I have a bias in it. I don't think they should be used because I don't think that you're interacting with an experienced, educated lawyer. A lot of people do it to save money. In most circumstances, I will tell you, a lot of people go on to Google and create a template, or they use one of the services. Homemade wills are very, very dangerous. I have not seen a scenario where people do homemade wills, again, setting aside the template of, the services. I'm not that familiar with the services, but I can tell you the Google template is not sufficient in my opinion. And most of the wills that people do themselves are contested in the courtroom. Sometimes they're not even admitted to court in probate proceedings. So if you want to use one of the services, it's entirely up to you. There may be some good ones out there. I'm just not familiar with all of the services that exist without consultation with an experienced lawyer.
All right. Do people you appoint, like a trustee, an agent under a power of attorney, an executor, do they have to be within the country as a U.S. citizen or a permanent resident?
Yes.
Okay. How is a toady different than creating a quitclaim deed with both the owner and the intended recipient?
Well, a quitclaim deed is the transfer of a piece of property from A to B. That's a quitclaim deed. Carrie gives his property to someone else. That's a quitclaim deed. A toady is exclusively used upon death. Carrie, upon his death, transfers the asset to his wife. So they're completely different purposes. A quitclaim deed is used perhaps as a gifting from one person to the other. In a real estate transaction, your buyer's going to want a warranty deed. So a warranty deed is you warrant that you own the property that you can transfer. Very different documents.
Okay. If you leave your financial assets to one person in your will, and then that person passes away with, after inheriting your assets also, can you put a note in your will that says when this person passes, you want your remaining assets to go somewhere else?
No, absolutely not. That person would have to do a will of their own. So if A dies and leaves the assets to B, and you're saying B then dies, can A tell somebody I want my assets to go to C? The answer is no.
Perfect. Do you have to go through probate if most of your assets over 150,000 have designated beneficiaries?
The key to the question there was most.
Right.
If you have assets in your name alone in excess of 150,000, the answer is yes. If you designate your assets in beneficiary designations or joint tenancy, 100%, you can avoid post-death probate.
Why is a power of attorney necessary for a spouse?
I'm not sure I understand the question.
I think this is because of the Healthcare Surrogacy Act.
Healthcare Surrogate Act.
Yeah.
Because the Healthcare Surrogate Act is, you're in the emergency room, they want to know if they can do brain surgery and they can't reach you. Okay? Many people put their power of attorney for healthcare with their internist or, the doctor that they may be consulting for problems. If you're available and if you're easily accessible, and if they can do it perhaps on the phone or if they can do it in the ER, you might be able to do it that way. But it's much better to have the document and put the document with your doctor, take the document to the emergency room if you have to go there. It's a smoother scenario.
Are there any ongoing fees for having a trust?
In general, no. If you name a bank as trustee, the answer is yes.
What is meant by avoiding guardianship via a revocable trust?
Well, we've talked about a lot of concepts and a lot of terminology tonight, but the reason that you can use a revocable living trust to avoid guardianship is you name yourself as trustee, you put your assets in the trust, and when you become incapable, you have named a successor trustee. So I name myself trustee, I put my assets into the trust, I name my wife successor trustee, I have a stroke, and she's able to manage my assets and avoid that lifetime guardianship case.
Can trust beneficiaries be foreign individuals?
They can, yes.
Is the $150,000 value to avoid probate per asset or the total of all assets?
Collective total.
If I'm single, can my agent live in a different state?
Yes.
Do beneficiaries still need to pay taxes?
Assume you're talking about on the property. In Illinois, the threshold to pay Illinois taxes is $4 million. So, but yes, the recipient, should they get that kind of money, is going to pay taxes.
If I pay an attorney to create a will for me in Illinois and a few years later I relocate to Florida and die in Florida, is my Illinois will valid?
I would encourage you to change it to Florida law. State law is very particular. I would encourage you to, depending on your age, when you plan to move, it would be a good investment to do it in both states.
Let's see. How should an heir's property be split amongst multiple relatives and ordered to stay within the family? Is there a strategy that you would recommend?
Tell me what the first part of the question was.
So, yeah, how should an heir's property, it sounds like how should the inheriting heir, how should their property be split amongst their relatives to stay within the family? So they want inherited property to stay within the family. Is that something that is possible, and is there a strategy for that?
Well, the only way you can do it is not basically give them ownership of the property. You could create a trust in which they could live in the property for, their lifetime, and then the next heir, so to speak, can live in the property. But if you give someone ownership of property, they can transfer it any way they want.
All right. I'm not sure that I understand this. What happens if I have power of attorney for my mother, but not my father, and my father passes away? Does that mean that I can act on behalf of my mother to manage any of their assets?
Well, if you don't have power of attorney for your father and he passes, don't forget powers of attorney die when you die. Power of attorney is a lifetime only document. Unlike a will, it has no validity until you die. So powers of attorney die with you. And you could manage your mother's assets after the death of your father, yes.
Okay. Let's see. I don't know that we can even necessarily answer this. How is the tax calculated if trust beneficiaries are foreign?
No, we can't answer it. Depends on what law applies, where they live. Is Illinois law going to apply? Things of that nature. It's well beyond the realm of this presentation.
Got it. We have a nice comment here, thanking you and saying that they're 35 years old and you opened their eyes a lot to all of this.
Good. Well, thank you for coming, and I appreciate your comment.
And then everything else, there's questions about cost, things like that. Give our office a call. That's the best way to go over that.
Yeah.
All right.
It is
well,
7 o'clock.
I think
So
we've timed it just perfect. Mark, you want to come back and join us at 7 o'clock? Ladies
yeah,
and gentlemen, I thank you again for joining us tonight. Give us a call if we can help you. Again, free initial consultation in the 4 offices that you see on the screen. And we look forward to the next presentation. So thank you, Mark.
awesome. Thank you so much, Carrie. And thank you so much, Lauren, for running the questions. I'm going to stop the recording now, and we'll email all the registrants a link to the YouTube video when it's up, so you can watch this and listen to all the answers again. So yep,